All right, let's talk about DUI. This is driving under the influence. This is found under Texas Alcoholic Beverage Code 106.041, and this covers a situation, so many other states call our DWI DUI. That's the equivalent in a lot of states. There's some states where it's OWI or OUI or some strange terms that are the equivalent of DWI in Texas. We don't, so we call DWI DWI. There is a Class C DUI statute, and that covers minors who have been drinking, and it's a very low threshold. So basically it's a Class C offense with up to a $500 fine only. An officer can arrest you for that, and if they pull over a teenager, a lot of times what we see is a person giving an officer attitude. They're not cooperating. The officer is agitated or annoyed, but they know the person who is underage has been drinking, but they don't think they're intoxicated. Just a caveat, an officer can arrest an 18, 19-year-old, 20-year-old, or anybody who's underage for DWI. They can do that. But if an officer sees that a person has been driving who is underage and they have been drinking, then this is where this statute could come into play. And we do handle this occasionally. But the threshold of what they have to prove is very low. It's not intoxication. It says that there's any detectable amount of alcohol in the minor system. So if the officer just smells any alcohol at all, that is sufficient evidence if he came to testify to prove that a minor was guilty of DUI. Not the same penalties, not as big of an offense as DWI at all, but this is where people kind of get confused sometimes when they talk about DUI and DWI interchangeably. They're two different offenses, so now you know. Okay, let's get into DWI, Texas Penal Code 4904. Here's the elements. I'm not going to read everything off of every slide, but hopefully you'll have a chance to read these. We're going to pick apart a few of the elements that are highly litigated that we argue a lot in court. So this requires a person to be operating. That's a highly litigated term. A motor vehicle, that's pretty well defined. But then a public place. Public place also can be litigated, even though the law has pretty much said almost anywhere is a public place, but we'll look at some of that. So if it is, and this also points out that if it is shown that you have a 0.15 or more BAC at the time the analysis was performed, that turns it into a Class A, which is interesting because in Texas, you cannot drive while intoxicated. At the time the analysis was performed, if a person's arrested and they go to the police station, you could have 2 hours that go by or 3 hours. I've seen 4, 5, 6 hours before they draw a blood test. Well, if your blood is or breath is above a 0.15 at that time, many hours after you were driving, then they can turn this into an upgraded Class A. That doesn't even talk about what your BAC was at the time you were driving, which is what the state needs to prove. So I think this statute was could be reworded to be more effective because the BAC at the time of the analysis really is irrelevant to show if you were intoxicated or not at the time of driving. So it would make more sense that that would say 0.15 or higher at the time of operating. Okay, intoxication can be proved in 3 different ways. We have kind of 2 bullet points here, but it's not having the normal use of your mental faculties, not having the normal use of your physical faculties, or having a 0.08 or higher. And it doesn't say at the time of driving, but Texas is a time of driving state. And the only BAC that matters for a conviction is what was the BAC at the time the person was operating the motor vehicle.